Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, we are pleased to announce that we are on the verge of completing our series on intellectual property rights. Dear friends, as you know that in our previous session we have discussed on compulsory licensing in India. In context to our previous session, we would be discussing on a case study and for a discussion we have again with us in our studios Mr. Ashwini Siwal. Mr. Ashwini Siwal is Assistant Professor in IP and Data Security Law, Faculty of Law, University of Delhi. So dear friends, I would like to welcome our guest Mr. Ashwini Siwal, under whose guidance we would be discussing on a case study pertaining to compulsory licensing in India. Hello sir, welcome to the EDISET lecture.
Hello Gitika, good morning. Good morning viewers. Well, as rightly mentioned by Gitika, that we are on the verge of completing our series on patent law in intellectual property. Well, friends, as she has just put across that we are discussing right now compulsory licensing in India, and especially our today's discussion would revolve on a case study, that is a case study of year 2012. In year 2012, that is Natco versus Bayer. Well friends, before jumping straight away to the case study, I would like to recapitulate few points to make you recall as to what we covered in our previous discourse, because whatever we covered in our previous discourse is somehow related and relevant as far as appreciation of our today's case study is concerned. So for that matter, I would like to take you to the previous discourse where I covered the compulsory licensing regime in India. For understanding the compulsory licensing regime in India, if you remember friends, we discussed the distinction between the compulsory license and the voluntary license. Further, after completing the distinction between voluntary license and compulsory licensing, we discussed another important thing. We understood the legal provisions relating to compulsory licensing in India, and the legal provisions which are relating to compulsory licensing in India are in the Patents Act 1970, that is our domestic legislation, wherein we saw the threadbare analysis, and we did this threadbare analysis of section 84, section 92 and 92A. These three provisions, friends, are very crucial as far as the law relating to compulsory licensing in India. Apart from that, in our previous discourse, friends, I discussed some international instruments giving us the empowering us for the purpose of compulsory licensing in India. And in that case, for that we understood the Paris Convention 1883, especially Article 5A of the Paris Convention, and TRIPS basically does not as such speak about the compulsory license, but it allows the use in another manner, in an authorized manner. So see, from the bare provisions of the Patents Act 1970 and international instruments, that is your TRIPS and Paris Convention 1883, we understood that there lies a flexibility as per these international conventions and instruments, and in light of that flexibility provided therein, our domestic legislation incorporates three major provisions to deal and to talk about the compulsory licensing in India, which we dealt perfectly in our previous discourse. If you recall friends, section 84 along with the section 92 and 92A, these three provisions as I highlighted are very important, because 84 tells as to how a compulsory license would be granted and to whom it would be granted, what would be the manner of application for the compulsory license, for the obtainment of the compulsory license, and what are the factors to be considered by the controller or by the official in determining the case of compulsory licensing. For that matter, we understood certain considerations given under section 84(6), or you can call subsection 6 of section 84, which elaborates and enumerates some of the factors to be considered while granting the compulsory license to the applicant. And any interested person can be an applicant, friends, for obtaining the compulsory license. But under section 84, if you remember, it was only in a case when 3 years had already elapsed from the date of the grant of the patent. So if somebody is interested to get the compulsory license, then in that case he or she has to wait for 3 long years because during those 3 long years we expect the patent owner or the patent holder to make the invention, to make the pharma invention in this context workable. After that, one can apply for obtaining the patent, and some of the factors given under section 84(6) are to be invoked by the patent controller in finally deciding whether a patent can be granted or not. Well friends, let us move ahead with this background to a case study where we will see the real application of the factors to be considered, where we will understand the real application of some of the intricacies that one faces and encounters, especially in the cases of compulsory licensing. Let us start directly with the case study, that is Bayer versus Natco, and this case study is one of its kind in the history of Indian Patents Act 1970, because see, post TRIPS it is one of its kind, or you can say post amendment it is one of its kind. Earlier to 2005, when we did not have the product patent regime in India, we had some of the compulsory licenses granted in as an instance to be quoted, but after 2005 this is one of its kind. This Bayer versus Natco case study is one of its kind, because in year 2012 the Natco, the generic company, applies to the controller of the patents for obtaining the compulsory license on a crucial drug, and the drug's name was Nexavar, and its function or its utility, its therapeutic efficacy is to treat the cancer, especially kidney and lung cancer, friends. Well, this drug Nexavar, or you can say the clinical name of the drug is Nexavar. This drug Nexavar is important for the purpose of curing the kidney or lung cancer. Friends, it was available in the market, but the price of the drug was exorbitant. It was kept around 2.28 lakhs for a 1 month treatment for a patient, and the patient needs it for a long time. He or she at least should be administered with this Nexavar drug for a year long to finally get rid of the cancer or to mitigate the symptoms of the cancer. As the drug was available at a very exorbitant price, at an expensive rate, the Indian generic company applied for obtaining the compulsory license, because the 3-year period has already been passed after the grant of the patent to the Natco in this case. Well friends, let us see what are the relevant facts as far as this case law is concerned. I will take you directly to some of the chronological fact sheet, or to fact sheet in chronological manner, where this case law is decided by the patent controller initially, then later on the case went before the Intellectual Property Appellate Board. After that the case goes to the Bombay High Court, and finally the Apex Court decided the matter, and finally stopped the controversy relating to Bayer versus Natco. Let us see the fact sheet of the compulsory licensing case law. This is Bayer versus Natco. If you have a look at the fact sheet, this Bayer is international drug manufacturing firm, friends, and it has a advanced kidney cancer drug which received a patent in India in the year 2008, and the drug name is, as mentioned by me, is Nexavar. Well friends, this multinational drug manufacturing firm sells Nexavar at 2.8 lakh rupees for a month, which is kind of unaffordable for a country like India, which is populous, and for country where, for other countries also where the patients are in high number as far as this disease is concerned. In India, it was noted that at the time this case law was contested, there were around 8,000 patients, or more than 8,000 patients in India, but at the end of the day only 200 patients were getting the treatment, rest were not able to afford it. So you can easily make out as to how many people are getting access at such an unaffordable price of 2.8 lakh rupees for a month. Well, if you see some of the more facts, Natco is a generic company, friends. It sells the drug at mere 8,880 rupees per month, and this generic company is offering to sell the drug, same Nexavar, having the same sold, having the same potential or potency in terms of its therapeutic efficacy at 8,880 rupees per month. So the question is whether this generic company be able to manage to sell the drug at mere 8,880 rupees per month when Bayer, which is an international drug manufacturing firm, already got a patent protection in India in 2008, has already obtained a patent protection in India in 2008. So see, the Bayer had to either license it to make it available at large or to the people at large, but Bayer did not license it to Natco. So Natco had only one option left in that case. Natco had to apply for obtaining the patent through compulsory licensing, or either go for the voluntary licensing, asking the Bayer, which is an international firm, for obtaining for granting Natco this voluntary license, so that Natco will be able to make the drug at an affordable price of 8,880 rupees. There is a sharp difference between the price range, if you can make out. On the one hand, it is mere 8,000 rupees, affordable to many people in India, but on the other hand, in the case of the international firm, it is friends around 2.8 lakh rupees for a month, and one cannot really afford in case of paying it this exorbitant money for a month, especially in a country like India. If you see some of the more facts as far as this case study is concerned, which is a case study on compulsory licensing. On 9th March 2012, the patent controller granted a compulsory license to Natco Pharma to market a more affordable version. Well friends, Natco initially applied to Bayer for obtaining the voluntary license, because applying for a voluntary license is an option available for generic companies, and any multinational or any patent holder or patented technology can be voluntarily licensed to multiple people or to multiple generic companies. So Natco initially tried for obtaining the voluntary license from Bayer, but Bayer did not entertain them and did not allow them to come up with the generic version of the Nexavar. So finally this Natco, seeking license on a Nexavar drug and promising to make it available at such an affordable price, went to the controller of the patents through a compulsory licensing regime and applied for the compulsory license, and they were granted the compulsory license on this drug in year 2012 on 9th of March. Well friends, if you see some more facts and chronology in this case, in the order granting the CL, the patent controller had noted that as against the demand of 8,842 patients in the year 2011, Bayer had supplied the drug to less than 200 patients after more than 3 years of grant of the patent. So this was the noticeable finding by the controller in this case, that Bayer had not been able to meet the reasonable requirements of the public, had not been able to finally make the drug available to the people at large at an affordable price, has not been able to work upon the invention in India. These are three considerations, or were three considerations before the patent controller while deciding this compulsory licensing suit or compulsory licensing application. One is whether the reasonable requirement of the public are met or not by the patented invention. Another factor to be considered, and as considered in this case law by the patent controller, was in the form of making it available at an affordable price, so that people at large can be able to access it without paying exorbitant money. And the third consideration, or the third factor, the final factor, its working has to be seen, whether it is working in India or not, it's workable in India or not. If it is not workable, it means it has failed into their promise while obtaining the patent protection to work upon the invention in the country, in the respective nation. Well friends, on this note, we can understand that these three grounds are taken or appreciated by the controller are very cogent and convincing, and on the basis of these three grounds and three considerations, the patent controller had noted as against the demand, as against the Bayer, which is an international firm, multinational company owning a patent on that drug. We'll continue this discussion as far as these three considerations are concerned by invoking section 84 of the Patents Act 1970. If you see some of the more facts as to what happened after controller granted the compulsory license to the NATCO, Bayer did what? Bayer kind of applied to the Intellectual Property Appellate Board in an appeal, and then further to the Bombay High Court. If you see, another factor which is very crucial to note, Bayer used to import the drug from other facilities instead of manufacturing it in its facilities in India. So the working part was not fulfilled, or the criteria of working was not fulfilled by Bayer, which is an international firm in this case, and that is why they failed, or they kind of lost the battle before the controller of the patents. Another thing, that Bayer failed miserably in catering to people. These are some of the jotted points or noticeable aspects while deciding the case or while deciding the compulsory application before the controller. Bayer started its Bayer Patient Access Program only after compulsory license proceedings were initiated. Another important point, friends, that Bayer pleaded before the controller that they have started a patient access program. But this patient access program was initiated by Bayer only after this compulsory proceeding application was filed, or compulsory license application was initiated before the controller. Had they started it earlier, they would have kind of made the controller convinced, or tried to convince the controller that they have some sort of philanthropic regime available in as far as the exorbitant prices of the drugs are concerned. But they started the access program for the patients later or post the compulsory license application, not pre-compulsory licensing application. So this patent controller granted a CL to NATCO with royalty rate of 6%, friends. This is at the first instance where the patent controller was listening and deciding the matter on some of these crucial considerations, and highlighting and vehemently jotting down these some crucial considerations. By putting these conditions in mind, and by keeping these conditions in mind or considerations in mind, the controller decided that the royalty rate to be paid to the owner of the patent would remain 6%, and that royalty of 6% has to be paid by the generic company, which is NATCO in this case, yearly, on an yearly basis, to the original patent holder, which is Bayer. So you can easily understand that Bayer lost the battle on the compulsory licensing, and NATCO obtained the compulsory license, wherein NATCO was asked to pay 6% of its total revenue from that drug on an yearly basis to the Bayer. In appeal, you see, the Bayer who lost the battle before the controller went into an appeal to the Intellectual Property Appellate Board, but surprisingly, Intellectual Property Appellate Board, and fortunately Intellectual Property Appellate Board, upheld the same as decided by the controller. Upheld the compulsory license application, but revised the rate of royalty to be paid from 6% to 7%. That is not that crucial. Revising the rate of the royalties is not that crucial, because see, the generic company promised to make the drug available at 8,880 rupees for a month period, for a month-long period to the patient. So, it was generic companies' headache to pay the royalty. It is not at all from the point of view of the public that they have to pay the more money for obtaining the drug or for having an access to the drug. So they were not bound. The public as such did not have any kind of accountability as far as this royalty revision is concerned. But what is important here to note is that the controller granted the compulsory license, the Intellectual Property Appellate Board upheld the compulsory license granted by the controller of patents, and shown the faith into the rights of the people, shown the faith in making the drugs accessible to the people at large. If you go ahead with the fact sheets, friends, we see after losing the battle before the controller in the first instance, and then before the Intellectual Property Appellate Board, Bayer approached the Bombay High Court by way of writ petition, alleging that the decision of the Intellectual Property Board was arbitrary. The Bombay High Court dismissed this writ petition, upholding the order of the Patent Controller and the Intellectual Property Appellate Board. So that is why I say this kind of a case is first in the history of India and first of its kind, because it had never done prior to this occasion, where all channels or all officials starting from the very first year, Controller, then Intellectual Property Appellate Board, then the High Court and then Supreme Court, decided unanimously in favor of the applicant for compulsory licensing, or in favor of the applicant for compulsory license and against the international firm. So this is the first of its kind, where unanimously or consensually all 4 different channels or 4 different authorities decided in favor of the generic company to make the drug available, to make the pharmaceutical invention available to the people. Well friends, after losing the battle before the Bombay High Court, we will consider as to on what grounds the Bombay High Court, and earlier to this Bombay High Court, the Intellectual Property Appellate Board, and before that, earlier to that also, before the Controller, as to how this compulsory license was granted and on what parameters of the Indian Patents Act 1970, under what provision of the law this was granted, or what are the appreciable provisions of the Indian Patents Act which were taken into consideration by all 3 incumbents or all 3 different channels, especially Bombay High Court and Intellectual Property Appellate Board and your Controller. After this Bombay High Court writ petition dismissal, the international firm Bayer filed a special leave petition, SLP, before the Supreme Court, and Supreme Court did what? Supreme Court also decided against Bayer. Though if you see the argument pleaded or raised before the Supreme Court by the senior advocate Mr. Sudhir Chandra for the counsel, or for the Bayer, for the international firm, he has made very strong point, or kind of appreciable point, that the Bombay High Court in its judgment had made unsustainable findings on several questions of law and fact, especially on question of making the drug workable in India. The third parameter on which the Controller decided the case in favor of generic company, as to how the patent is to be made workable in India, or what constitutes working of the patent in India. On this question, which became very controversial later on, the advocate, senior advocate Mr. Sudhir Chandra vehemently opposed and alleged that the Bombay High Court decision as well as the decision of the Intellectual Property Appellate Board were arbitrary as far as the third point is concerned. Well, he contended again or further, for instance, while considering whether a reasonable requirement of the public had been met by the patentee under section 84, the Bombay High Court should have taken into account Cipla's infringing sales. Well friends, this is one more interesting fact which I forgot to put across, that there was another generic company, Cipla, making the drug available in 30,000 rupees for a month, available to the patients. And Cipla as such was instituted by Bayer for an infringement suit for the same drug Nexavar, though Cipla as such was not a party to this compulsory license, as Cipla was making available the same drug, same Nexavar, in rupees 30,000 per month. So the lawyer here of the Bayer of the international firm in an SLP before the Supreme Court tries to convince the Supreme Court, or tried to convince the Supreme Court, that Cipla, by infringing the patent of Bayer, is making the drug available to the patients. So the Cipla's availability of the drugs, or drugs availability made by Cipla, should be taken into account, and the case should not be decided against Bayer. It should be decided in favor of the Bayer, because through Cipla, or through the infringement sale of the Cipla, the drug is accessible to the people at an affordable price in India in rupees 30,000 rupees. Well, in 30,000 rupees for a month. Well, one thing which is very noticeable, friends, here, see, Cipla was already an infringer of this Nexavar drug in India, and Cipla was instituted for an infringement action by Bayer in Delhi High Court. So a parallel suit was going on in Delhi High Court against Cipla by Bayer. On the other hand, Bayer is filing an SLP to the Supreme Court challenging the decision made by the Intellectual Property Appellate Board and by Controller and by Bombay High Court for a compulsory license of Nexavar. So these two things are kind of contradictory, where they are entering into a separate litigation of an infringement against Cipla. On the other hand, they want to take a benefit of this Cipla's infringing sale, where Cipla is making the drug available by infringing the Nexavar as a patented thing or patented drug. We will discuss it later, friends, in a very threadbare manner. Well, another thing that is very important to be noticed, the bench also noted that Bayer failed to supply Nexavar to a significant number of cancer patients required the drug despite its patient access program. This is what Supreme Court noted, and Supreme Court highlighted while denying while dismissing the SLP or while entertaining the SLP of the Bayer. Another thing, that SLP was dismissed by Supreme Court finally on these two previous important grounds, that Nexavar is not available to the significant number of cancer patients, one thing, and another, that they have not been able to make the or fulfill the requirements of the public at an affordable price. Well, friends, that's all as far as Bayer versus Natco case study is concerned. I mean, as far as the fact sheet of this case law is concerned, we'll have to see the law points in question in this case law to finally, understand the case law in an analytical manner as to what are the provisions which were invoked or which got invoked in this case law, and what are the rest of the things to be taken into consideration or was taken into consideration at the time of decision given in this case law by the Supreme Court, by the Bombay High Court, and in the first instance by the controller itself, because controller has been very instrumental in this case law. Controller Mr. Kurian decided it by taking a very strong stand, because it was kind of unprecedented in the history of India. It had never taken place post 2005 amendment. Early to that, there were certain compulsory licensing instances available with us, but post 2005 this is one of its kind. So we will take up as to how Mr. Kurian, controller of the patent, decided it, what provisions he took into the consideration, and how Bombay High Court and Supreme Court finally made the controversy settle down, or kind of completed the controversy by deciding it through the apex court. I'll meet you in the next session, friends. Thank you so very much. Thank you. Welcome, friends, to the next session. Well, in our previous session, we saw the fact sheet of Bayer versus Natco, which is a case study in our discussion, and the discussion title is Compulsory Licensing Regime in India. Well, as I said in my previous session, friends, that this is one of its kind, a case study as far as compulsory licensing in India. So from the understanding of the fact sheet, we can conclude that Bayer finally lost the battle and NATCO won it, despite the fact that there was one parallel infringement going on by Cipla, which is again a generic company in India. So somehow this Cipla's infringement had been beneficial, because this appellant Bayer in this case before the Supreme Court alleged that Cipla's infringement should also be taken into consideration to finally decide the matter, which Supreme Court find very obnoxious or kind of absurd statement, absurd allegation, because the Bayer, which is the present appellant in this case, had a separate infringement action or a suit going on before the Delhi High Court against Cipla. Well friends, as I promised in my previous session that I will take you to some of the important provisions of the law which were taken into consideration by Mr. Controller or by Mr. Kurian, Controller of the Patent in India, in this case law granting the compulsory license to the applicant NATCO. Let us see what are the case law, what are the provisions which were taken into consideration, friends. If you have a look at the domestic legislation, Indian Patents Act 1970, we have three provisions. We have section 84, we have 92 and 92A, dealing or squarely encompassing the law relating to compulsory licensing in India. If you have a look at, friends, section 84, compulsory license under section 84 can be granted to any person interested to get the or to fetch the compulsory license after the expiration of 3 years from the date of the grant of the patent. So very first thing that was into the mind of the controller while entertaining this application in the case of Bayer versus NATCO was to see whether Bayer had already exhausted the 3-year time period in coming up with the workability of the invention or in making the invention workable in India. So the very first thing to be seen, to be scrutinized as far as the Bayer versus NATCO case study is concerned before the controller was to see the cessation of the 3 years time period. If the 3-year time period has already cessed, has already concluded, only then an interested person can make an application. Some of the more factors that will come and in the ensuing provision or in the provision in the ensuing stage. See, any person interested can file the patent application after the grant of the patent. In some of the situations, what are those situations? If you have a look at the slides, the very first situation, by invoking this situation, an applicant can make an application to the controller of the patents, and it reads that the reasonable requirements of the public with respect to the patented invention have not been satisfied. Let us deliberate little upon this requirement of making the drug available, or you can say meeting the reasonable requirements of the public as far as the invention is concerned. So in this case study, Bayer versus NATCO, as I have already told you in the fact sheet, that the drug was beneficial only for 200 patients out of 882 patients seeking the availability of the drugs in India. As per the fact sheet, we have that data available that only 200 patients were catered by Bayer because the drug was too expensive or too exorbitant in its price that Indian populace were not able to have or use that drug, particularly Nexava or a drug, for their treatment, for their disposal. So see, as far as this first requirement is concerned, under section 84, it is kind of very easy to figure out that controller had not been in a difficult position to invoke section 84A because the reasonable requirements of the public are not getting satisfied as far as this fact sheet is concerned, where only 200 patients are catered by this drug Nexava, given the fact that 8,000 patients were seeking the drug availability, were seeking the treatment. So one can easily make out that only 1% or to an extent 2% or above people, 2% or above were in access to this drug, and rest of the society were deprived. So it seems that the reasonable requirement of the public was not satisfied by this drug, and this is what controller zeroed in, controller concluded as far as 84A is concerned, and he invoked section 84A and decided in favor of the generic company on this ground, on the ground of meeting the reasonable requirement of the public to satisfy their need to make it available. The next thing under section 84, which is very crucial, it says that after the expiration of the 3 years, any interested person may make an application to the controller for grant of compulsory license if the patented invention is not available to the public at a reasonably affordable price. Well friends, in our scrutiny to the first clause 84A, we have seen the fact matrix that says that the drug was available but its price was very exorbitant. In this question, the price was around 2.28 lakh rupees for a patient for a month long treatment. So in India and in many parts of the world, it is not possible for the patient to have an access to a drug of such an exorbitant rate, of such an expensive rate, which comes at 3 lakh rupees in 1 month or for a month long treatment, because the paying capacity of the patients in India or in many parts of the world is not meeting or is not coping, it can never cope up with this kind of a price. So when it comes to second question before the controller, or this clause 84B before the controller, we can easily make out that controller was right in determining that the drug is not available at a reasonably affordable price. But on the other hand, the applicant for compulsory license proposed to make the drug available at mere rupees 8,000 for a month long treatment, which is a very remarkable thing and appreciable thing. On the other hand, Shipla was making it available in 30,000 rupees. Well, Shipla's question is to be decided separately, because Shipla was not a party in this case. Still, it was kind of invoked by Bayer in the SLP before the Supreme Court. If we see, as our discussion is restricted only to the controller's stand and controller's application of law and application of facts, we can conclude that that controller was right in determining that the drug is not available at an affordable price. Had it been available at an affordable price, so the question of invoking section 84 would not have a reason. But as the drug was unavailable and the drug was not meeting the requirements of the public, was inaccessible because of the high rate, so it is kind of clear, apparent, that controller had to decide against the Bayer and decide in favor of the NATCO. Well, one more interesting thing as far as 84B is concerned, friends, that you see, controller, while determining on the grounds of section 84 or on the requirement of section 84, noted and jotted clearly that the patient access program driven or run by Bayer, by this international multinational firm, was post compulsory license application, was not before compulsory licensing application. Had they been providing this access program to the patients prior to the litigation or prior to the compulsory licensing application, they would have been able or successful in using this particular plea, or in availing this plea that they run a access program for the patients where they provide the drug to patients for 3 months free of cost, and for 1 month they charge the full amount of 2.28 lakh rupees. In resultant, you can say, making the drug available to the patient in 30,000 rupees per month. But if you see this philanthropic aspect of the Bayer, we find that Bayer had not been able to cater many people through this access program, because in India it is not possible for a patient to pay even the 1 month cost of the Bayer's product, which is 2.28 lakh rupees, and to enjoy the the access to the drug later on for the next 3 months, because it may be a situation where the drug is required to be availed by or consumed by the patient at an urgent basis, but as the drug is available only by paying 2.28 lakh rupees and the patient fails to accumulate 2.28 lakh rupees, so he won't be able to enjoy the 3 months free of cost drug, because it is really illogical and absurd an argument, philanthropy kind of argument, because see, this philanthropy done by the Bayer was kind of illogical and absurd philanthropy, illogical philanthropy. The third thing, or third 84C, which is a ground again under which a patent invention or a patented invention can be given in a compulsory license to the person, is very controversial and is very important to deliberate upon. It says and it reads that a compulsory license can be granted to a person on a patented invention if it is not worked in the territory of India. Well friends, as far as the working in the territory of India is concerned, working has not been defined anywhere in the Patents Act 1970. So what would constitute working? For that we need to have look at certain judicial interpretations as far as the word working of the patent in India is concerned. And in Indian jurisprudence there is no judicial interpretation available for working of the patent. So for that matter we have to refer certain writings available of jurists, of good scholars, and then we have some judicial dictas available of foreign jurisdictions, of other jurisdictions, where it has been decided as to what would constitute the working of the patent in the respective nation, or as such in totality what would constitute the working. Because the main question before the controller to be decided in this case law was whether the patented invention, in this case the drug Nexavar, is in working or not in the territory of India, as the word written here is in the territory of India. So what do we need to prove that the drug Nexavar is in working in the territory of India? Do we need to prove the availability of the facilities or the manufacturing of the drug in India, or do we need to prove only one thing, that it is being exported from other nations and being made available in the shops across the nation? So see, that is how we can decide. Only two things are available with us, two analogies are available with us. One is, are some manufacturing units existing, established, situated in India, manufacturing the drug in the territory of India? Another factor to be considered, or logically to be considered, possibly to be considered while determining the working of the patent in India, is it imported from other nations and then it is being made available at the counters to the people at large? So that was the crucial question to be decided, but the controller decided that the drug is not in working in India because there are no manufacturing units in India, and the major portion of the drugs, or maximum Nexavar drug, is imported by Bayer from other parts of the country, and it is not manufactured in the territory of India by the Bayer. That has kind of remained very crucial finding by the controller at the first instance, that Bayer does not manufacture the drug in India, it imports the drug from outside and makes it available to the people by importing it. If you see this, then I'm reminded of one very good writing of one very good scholar, Professor Shyamnath, who says that maximum drugs in India, or 90% of the drugs in India, are imported, are not manufactured in India. So can we think of granting the compulsory license in each and every case where the drug is not manufactured in India but it is sheer imported from other countries? It would remain little controversial. It has to be decided finally by the court, because it is a writing of the good scholar who says that it has to be checked whether the drug can be made, can a compulsory license be granted to a person on this on this particular ground, that the drug is not manufactured in India. As controller in this case took note of this situation and decided that the drug is imported in India, So it fails on working, it fails on the requisite of working, and 84C can be invoked in this case so that interested person get the compulsory license because the drug is not workable, not working in India. Well friends, some of the more factors to be considered by the controller, as promised by me, that I will discuss from the point of view of the provisions to make you understand what are the factors to be considered by the controller. Especially in this case, the three factors which were considered by the controller are as follows, given under section 84A, B and C. I have one more important thing to discuss friends as far as 84C is concerned. See, section 84C tells that the patented invention, if is not in working in the territory of India, in that case a person interested can apply for the compulsory license to the patent controller, and the patent controller has the power invoking section 84C to grant the compulsory license to the applicant. Well friends, as noticed by a good scholar, Professor Shamnad, in one of his writing in way back in year 2005, I mean prior to this compulsory license application, and otherwise in many other judgments of different jurisdictions, it is noted that working means manufacturing the drug in India or in the respective territory, in that respective nation. What does we conclude as far as this logic, this argument is concerned, that working only means manufacturing? We sometimes think, and we should think that a situation may occur where all the generic companies will start filing the patent compulsory application or patented invention compulsory application on this ground that the drug is not workable in India because it is not manufactured in India, especially in the pharma sector where 90% of the drugs are imported from other nations, are imported from other countries. So it may spur momentum, or it may give an impetus to the generic companies to go for the compulsory license application against all the drugs or drug manufacturers who are just importing the drugs from other nations and have got the patent protection in India through patent board or by filing the patent application in India. So well, as far as working in India or in the territory of India is concerned, controller decided that it is not working in India. Well, I have one more thing to discuss friends as far as the working in India is concerned. Of late, in year 2015 only, in the end of the year 2015 only, a writ petition was filed by Professor Shamnad itself before the Delhi High Court to see the utility of section 146 of the Patents Act 1970, and section 146 reads and requires the patent holder to show or to always provide with the statistics of the working of its invention, of the working of his invention in the territory. So far as this writ petition of section 146 is concerned, filed by Professor Shamnad, it is kind of clear by the very first step taken by the Delhi High Court, wherein they have passed a notice against the controller that they have to provide the statistics of all the patents available in India and their workability or their working in India, because as per section 146 the patent holder has to provide the statistics, provide the crucial evidence and record after the cessation of every 3 years to the controller that they have worked in the territory of India, and to this extent they have served the people, to this extent they have worked upon the invention concerned or invention in question. Well, in this case law, patent controller has noted down that the drug Nexavar of the bear was not available or not affordable and not working in India. So on these three separate grounds of section 84, he invoked all three provisions and decided that it is not available, not meeting the reasonable requirements of the public, and not available at the affordable price, is not worked in the territory of India, and he decided on certain considerations which are given under section 84(6), which are as follows, friends. Well, I am skipping few considerations and I am coming straight away to one of the important considerations given under 84(6). As on this slide on number 3, it reads that if the measures are already taken by the patentee or any licensee to make full use of the invention, in that case the controller will hesitate or has to hesitate as far as the application for compulsory license is concerned, or as far as granting of the application of the compulsory license is concerned, because he has to scrutinize whether the patentee, in this case the patentee was Bayer, and he was considering Cipla as his licensee, though Cipla was not his licensee at all, because Cipla was infringing the patented technology and using it, appropriating it unauthorizedly, but Bayer tried to make it as a licensee or project it as his licensee, though the fact of the matter is that Bayer was separately instituting an infringement action against the Cipla. Well, patentee or if the licensee are using the full use or making the full use of the invention, then in that case the controller will not grant the patented technology or say the compulsory licensing on the patented technology to the applicant. But if he finds that the patentee and the licensee has not tried or has not taken the measures to make the invention available to the people at an affordable price, has not been able to fulfill the or satisfy the requirement of the public, have not been able to show the working of the invention in the territory of India, then he or she can be asked to license it compulsorily to the applicant. Another factor which is to be seen while granting the compulsory license, or which was taken into consideration in this case study by the controller, was the ability of the applicant to work the invention to the public advantage. Well, friends, as far as the ability of our present applicant for compulsory license, which is NATCO in this case, the ability gets satisfied, or this consideration gets satisfied, because the applicant for compulsory license NATCO was ready to make the drug available in mere 8,880 rupees, and that would be certainly advantageous for the public at large. So the question on the ability was not that much important, or was not that much difficult to answer, was not difficult to decide for the controller, and he decided that NATCO had an ability as far as the invention to be made for the public advantage is concerned. Well, let us jump to another important thing to be seen, or which was seen in this case study by the controller. It is the capacity of the applicant to undertake the risk in providing capital and in working the invention. Well, friends, as the present applicant NATCO had the capacity, because they have been very known player in the market as far as the generic medicines are concerned, and they were ready to make the drug available at a cheaper price, and they had the manufacturing units in India making the drug available to the people at large. So as far as the capacity of this applicant is concerned, of NATCO is concerned, we can say that controller rightly find him capacious enough to make the drug available and invest the capital and working of the invention. Another important thing, friends, to be taken into consideration, and which was taken into consideration by the controller in this case, in this case study Bayer versus NATCO, whether the applicant has made efforts to obtain a license from the patentee on reasonable terms. Well, it remains very crucial to scrutinize on this aspect. Friends, NATCO in this case study applied to the Bayer in a previous occasion and offered to make the generic version of the same drug in an affordable price, but Bayer did not entertain their application. Bayer refused to grant them the voluntary license. So as far as the requirement of proving that the applicant should have taken certain measures or must have taken certain measures prior to filing the patent compulsory license application, in this case it was found by the controller that NATCO had already applied to the Bayer, and Bayer refused to denied to grant a patent to the NATCO. So we can say that all the crucial considerations were taken into care, into meticulous care by the controller in this case law, in this context, and section 84 and its grounds were squarely fulfilled or got fulfilled as far as this case study is concerned of Bayer and NATCO. Well friends, after this discussion I would like to take you to some important things which are very crucial as far as the regime relating to compulsory licensing is concerned in India. See, after the Supreme Court's verdict on Bayer versus NATCO, where Supreme Court also decided against Bayer and decided in favor of NATCO, we saw increase in the number of applications for compulsory licensing in India. If you see or have a look at this slide, the very first case, which is a successful case on compulsory license, it is NATCO versus Bayer, decided in favor of NATCO. Another case that came in the year 2015, friends, it is BDR versus BMS, where the drug Dastanib was in question, or the compulsory licensing on Dastanib was in question. It was rejected by the controller. But what is good and what is interesting to note here is that we saw the momentum in the filing of the applications for obtaining the compulsory license. No matter that the compulsory licensing in the second case after Bayer versus NATCO on the drug Dastanib got rejected, but at least we see, or we are watching and seeing some momentum, some impetus in filing of the applications in India on for compulsory license. The third compulsory license application which came after this Bayer versus NATCO, again of year 2015, it is in Lee Pharma versus AB, and it is on sexagliptin drug. Well friends, it also got rejected. So it shows that India has witnessed in the recent past some impetus, some spur in filing of the compulsory licensing, and this arena has become fighting ground for lot many generic drug manufacturers with the multinationals, which undoubtedly will pave a way for a country like India to have an access to the medicines and to make the drugs available at an affordable price. No matter that some of the drugs may get rejected, because it also strikes a balance, because otherwise India may be labelled as a country where compulsory license is granted to the generic versions instead of seeing the merit of the case. But it is not the case, friends, because as such the controller and the other appellate authorities in India are not deciding the matter by not taking into consideration the merits of the case. They do see or question the merit, and then only they decide the compulsory license application, determines the compulsory license application. Well friends, that is all about the compulsory license application, and I would like to hear from you something more about the compulsory license application, and I'm really expecting many more compulsory license applications to take place and to come before the controller India in the ensuing time to come. Thank you very much. I rest here. Have a good day.
Thank you, sir. Thank you so very much for giving us a prolific session once again. And dear friends, we would be meeting again very soon and would be discussing on the other aspects. Till then, take care. Goodbye. Thank you, sir.